Okay, thank you. Nice to have everybody here, and thank you for joining us today. My name's Hannah Beer. I'm a senior associate in our employment team, and I'm joined today by my colleague Lizzie, who will be presenting the slides today with me on settlement agreements. A couple of housekeeping before we get started. So throughout the presentation, all participants will be in listen-only mode. If you would like to submit any questions, we do have a Q&A function in the top right-hand corner. So you can type your question onto the Q&A panel there. We do have quite a lot to get through, so we will try and answer some questions at the end of the session. But if we don't have time, we will post our answers via a blog over the next few weeks. So don't worry if we don't get to the questions at the end. What we are going to be covering today. So the purpose of today's session, which will be for an hour, is to cover the legal and practical issues when entering into settlement agreements in the workplace. So we will have a reminder of the basics that Lizzie's going to take us through shortly, the difference between settlement agreements and COT3 agreements or a simple letter, key issues to be covered, including tax on termination and prohibited terms, practical tips on entering into a settlement agreement with employees, and then also some of the typical pushbacks that we might see from a lawyer who is advising the employee and how we typically respond to those. So I'll hand over to Lizzie now to take us through some of the basics.
Thanks, Hannah. Okay, so like Hannah said, we'll start with the basics to begin with. A settlement agreement is just another form of agreement. So specifically, it's an agreement whereby a current or former employee or worker agrees to waive or settle claims or other court proceedings against their employer, usually in return for a payment. Settlement agreements, like I said, are just another form of agreement or contract, so have most of the same strengths and weaknesses as ordinary contracts do, in that they are enforceable in some circumstances but not in others. Settlement agreements are usually entered into on termination of employment, but it's not always the case. For example, an employee might have brought a discrimination claim during their employment, and the parties may agree to enter into a settlement agreement to settle that particular claim. A lot of what we will discuss today will cover the terms in a settlement agreement around termination, but these aren't the only circumstances in which a settlement agreement might be entered into, and so it's just important to be aware of that. It's also worth pointing out that it's not always necessary to require a departing employee to enter into a settlement agreement. If, for example, an employee resigned of their own volition in order to start employment with an alternative employer, then you wouldn't need them to sign a settlement agreement unless the company suspected that they might bring a claim in future, or at least have grounds on which to bring a claim. As a settlement agreement involves an employee agreeing to waive certain rights, the employee will usually want to receive some form of payment in return for doing so, which means that it wouldn't be appropriate or financially viable for a company to require all resigning employees to sign a settlement agreement just to avoid the risk of any claims being brought against the company. A settlement agreement is most likely to be appropriate where, for example, an employee has already brought an employment tribunal claim and the employer wants to settle the matter and avoid the need to go to tribunal, or where an employee leaves their employer in circumstances where they might have a potential claim arising from their dismissal. It is also potentially appropriate to enter into a settlement agreement where the employer is paying a material amount over and above the statutory or contractual minimum that's due to the employee on termination. Now, if you pay an employee above the statutory or contractual minimum that's due to them, and you don't ask them to enter into a settlement agreement, and the employee went on to bring a claim, there isn't any actual guarantee that you will get credit for the money that you already paid the employee by the employment tribunal or the court that was considering the claim. Hence why, like I said, it's usually appropriate in those circumstances to be entering into a settlement agreement. Okay, so In order for a settlement agreement to be legally binding, there are 6 key requirements that it needs to meet, which are set out in statute under Section 203, subsection 3 of the Employment Rights Act. So the first requirement, which is pretty obvious, is that the settlement agreement has to be in writing. Secondly, the agreement must relate to the particular proceedings. So if, for example, an employee was claiming that they had a potential claim for unfair dismissal, then you would need to have clearly identified these proceedings within their settlement agreement, either by a generic description, such as unfair dismissal, or by reference to the section of the statute that gives rise to an unfair dismissal claim, which is Section 203 of the Employment Rights Act. It's not good enough for a settlement agreement to use a rolled up expression such as the employee waives all of their statutory rights. You need to give more detail than that within the agreement in order for it to be binding. The third key requirement is that the employee entering into the settlement agreement has to receive advice from an independent legal advisor as to the terms and effect of the agreement in order for it to be binding. Now, in particular, they need to have received advice on the effect of the agreement on their ability to pursue their rights in an employment tribunal. In other words, the employee has to have taken legal advice to enable them to understand what rights they are giving up by signing the settlement agreement. Now, a relevant independent advisor is usually going to be a qualified solicitor or barrister, although it can't be one who works for or advises the employer. But it could also be a trade union representative, for example, or an advice centre representative who has authority to give advice on the settlement agreement. The relevant independent advisor must be identified within the settlement agreement as well. That is, their name must be set out within the agreement, as well as the name of their firm or the union. The relevant independent advisor must also be covered by insurance, which will cover the risk of a claim being brought by the employee in future in respect of any loss that arises in a consequence of that advice. Finally, in order for a settlement agreement to be binding, the agreement must state the conditions regulating settlement agreements, which are set out in statute, have been satisfied. So by way of example, if we go back to the employee who might have a claim for unfair dismissal, their settlement agreement would have to state that the conditions regulating settlement agreements under Section 203 of the Employment Rights Act have been satisfied, as the Employment Rights Act is the piece of legislation under which an employee can bring an unfair dismissal claim. So if these 6 requirements, which are set out on the slide there, are met and the relevant boilerplate wording has been included in the settlement agreement, even if it sounds very formulaic, then this will ensure that the settlement agreement is valid. If you don't include the relevant wording and meet the key requirements, then the agreement won't be valid and it could be void. So aside from those 6 key requirements, there isn't a magic formula for a settlement agreement. Provided that the agreement incorporates the whole terms that have been agreed between the parties, whether that's financial terms, such as an agreement to pay notice pay or an ex gratia payment, non-financial terms, such as terms relating to the continuation of restrictive covenants, or cosmetic terms, such as the provision to do with the provision of a reference or an announcement, then the agreement should do the job. What might not actually be obvious is that whilst most settlement agreements require the advising solicitor to sign the agreement, this is actually not strictly necessary for a settlement agreement to be binding under Section 3 of the Employment Rights Act. Provided the advisor is identified in the agreement, like I just said, then this will be sufficient for statutory purposes. Although I would still say it's best practice to ask the advisor to sign the agreement. A settlement agreement may be the last time that an employer has any leverage over the employee, and so the burden very much is on the employer to ensure that the settlement agreement includes all the terms, obligations and restraints that you want to impose upon the employee going forward. Okay, so up until now, I've been speaking almost exclusively about settlement agreements, but it is worth saying that settlement agreements are just one of the valid ways that you can settle claims with an employee. There are other ways that you can validly settle claims, and it is just worth taking a little bit of time to talk about those now. So those other ways are by either using a COT3 agreement or by using a simple letter. So the use of a settlement agreement is very much a belt and braces approach, like it says on the slide there, as a settlement agreement is a valid way to settle both statutory and contractual claims with certain limited exceptions. The arguable downsides to using a settlement agreement are, like I said a moment ago, because the fact that the employee has to take independent legal advice on the terms of their settlement agreement before signing it, which can mean often that this complicates the negotiation process, and it can also lengthen the negotiation process as well. It can also mean, finally, that the process is more costly for the employer, as normal practice is for the employer to make a contribution towards an employee's legal fees. If we look then at COT3 agreements, these can be used to settle claims in more limited circumstances, namely to record the terms of a settlement that's been reached between the parties following conciliation with an ACAS conciliation officer. Now, one of the advantages of using a COT3 agreement is that the employee does not need to take independent legal advice on the COT3 agreement before signing it, which means that a COT3 agreement can be useful to use where you're dealing with an employee who isn't legally represented. COT3 agreements as well, it's also worth saying, are the only valid way to settle certain types of claims. For example, a collective claim for a failure to inform and consult under TUPE would be one of them. The main disadvantage of using a COT3 agreement is that an ACAS conciliation officer has to be involved in the negotiation of the settlement terms. So what I mean by that is it's not possible for an employer and an employee to use a COT3 agreement to record the terms of a settlement that they've reached between themselves. ACAS isn't going to rubber stamp a settlement that's already been reached between the parties. They have to be actively involved in the negotiation process. Now, that's actually causing a few problems at the current time because the ACAS conciliation service is currently very stretched. And so we are in practice seeing the delays to negotiations being caused due to the fact that ACAS aren't able to assign a conciliation officer to cases very quickly. Okay, so the final way that you can validly settle claims is by using a simple letter. Now, you can use a simple letter to validly settle contractual claims, but not statutory claims. So that's really important to remember. Using a simple letter can be a quick way of settling contractual claims, but rarely is it effective. The fact that you can't settle statutory claims using a simple letter is obviously a public policy decision because of concerns that employers would require employees to sign away all their rights if they could just ask them to sign a simple letter in order to do this. You might want to use a simple letter in circumstances where you're dealing with an employee who doesn't have 2 years service, for example, and so you haven't got the risk of an unfair dismissal claim there. And also where you haven't got any concerns about a potential whistleblowing or discrimination claim. It's also worth thinking about whether the reputation of the employee and whether or not the employee would be willing to damage their credibility by bringing a claim in direct conflict with a letter that they signed, agreeing that they wouldn't in return for receiving a payment. But like I said, rarely are you going to be using a simple letter to validly settle claims with an employee. You're either going to be using a settlement agreement or a COT3 agreement if that's more appropriate. Okay, and I'll pass back to Hannah now.
That's great. Thank you very much. So how do we actually enter into a settlement agreement and raise this with an employee? This is often the more difficult or tricky part of actually starting the settlement agreement conversation with an employee. And how do we go about that? So making the offer of the settlement is always a sensitive issue. And that's why I say it's important to consider carefully how and when to raise the matter with the employee. Probably everybody on this call has heard of without prejudice conversations and protected conversations. But what does that actually mean from a legal perspective, and how, as employers, can you make sure that you are entering into the conversations without creating any additional legal risk or unnecessary legal risk? So we've got two routes in essentially. We've got pre-termination negotiations, which are under section 111A of the Employment Rights Act. And this piece of the Employment Rights Act essentially enables employers to have confidential discussions with employees as a means of ending the employment relationship without a risk of those discussions subsequently being used against them in unfair dismissal proceedings. So it is helpful, the pre-termination negotiations part of the Act, but in a lot of circumstances, it doesn't exactly do what you as employers would want it to, because the rules only apply to unfair dismissal proceedings. So if there are any allegations other than that, so discrimination, whistleblowing, for example, that Lizzie mentioned earlier, that piece of legislation doesn't cover those conversations. So essentially, when it might be most useful, because they tend to be the more valuable potential claims that employees can bring at tribunal. So the difference between section 111A under those rules and the without prejudice conversations is that a without prejudice only applies where a formal dispute has arisen, and those without prejudice discussions cover all other types of claims that I've just mentioned, so not just the unfair dismissal that is covered by the protected conversation. So if a conversation is entered into on a without prejudice basis, there has to be a dispute that has arisen. So for example, contentious grievances, an employee who's threatening to bring claims, that may all be the basis of a formal dispute, or obviously where there are already existing tribunal legislation disputes, obviously that would be the appropriate time to have without prejudice conversations. So employers do need to be aware that if settlement discussions are not handled in the right way, employers can be guilty of what's called improper behaviour, and on that basis there would be a risk of the discussions being used against them at a later stage. And there's also a risk that an employee could resign and claim unfair constructive dismissal depending on their length of service. ACAS does have some codes of practice on settlement agreements, and for employers on making and recording settlement offers, the ACAS guidance, as you might imagine, is quite stringent, but I'll go through some of the key points in terms of how you're best to have those conversations. So an employer can open the settlement discussions and make an offer either verbally or in writing. So it's fine for the initial proposal to be made verbally, but obviously, as Lizzie's already mentioned, it would have to be put in writing later on for it to be legally binding. In practice, the most sensible approach would be for the company to invite the employee to attend a meeting at which they're then given the settlement offer. And we'll discuss routes into the conversation a little bit later on. It's important that the employer doesn't put any pressure on the employee to accept the settlement offer, as that could constitute improper behaviour, which would render any of the discussions admissible in a subsequent tribunal proceeding or on the basis of a constructive dismissal claim. But there's nothing to prevent the employer from setting out in a neutral manner the reasons that have led to the proposed settlement, or factually stating the likely alternatives if an agreement is not reached. So in reality, there is obviously some trigger to enter into the settlement discussions in the first place. And the way that we usually advise to deal with it is, again, to recap on a factual basis the circumstances that have led to it, and saying that this is an alternative route if an agreement isn't reached, there may be, for example, a formal performance management process, formal disciplinary procedures, a consultation under redundancy, for example. The most important thing is that nothing is said to the employee which prejudges the outcome of any of those processes. So it's fine to say, if we're not able to reach an agreement, we will be proceeding with formal performance management. But where it tips over is if an employer were to say, if we don't reach an agreement, you will be fired or your employment will terminate on this basis. That type of conversation is likely to fall foul of the rules on improper behaviour. So an employer should keep a note of anything that's said in the meeting, but make sure that it was clear that the conversation was pursuant to, for example, Section 111A of the Employment Rights Act, or that it was without prejudice, so that it can't be referred to in subsequent proceedings. Even if it's questionable at that moment whether there is a formal dispute, it's prudent still to mark any correspondence or any notes as without prejudice. Employees usually understand what that means, and it's helpful in terms of the paper trail for the intention of what the conversation was about. If the employee is happy to do a deal in principle, then they should be given a reasonable time to consider the offer of any settlement. That depends on the circumstances, but ACAS recommends a minimum of 10 calendar days to consider the proposed formal written terms. It's important to allow reasonable time for the employee to consider the offer, or they could claim that that in itself constitutes improper behaviour. And as I've mentioned, in terms of the agreement itself, the labels without prejudice and subject to contract that you probably see at the front of all settlement agreements, they make it clear that the settlement offer is being made on that basis. If the offer is being made as part of pre-termination negotiations, you sometimes would flag that on the agreement itself. So say covered by the relevant section of the Employment Rights Act. And then those labels are then removed from the final version of the agreement, provided for signature. Many agreements do include a clause in the body of the agreement which states that it will become open and binding once signed by both parties. And that's even if it still has those markers on. Obviously, once the agreement is signed, you want to be able to rely on it. So it's no longer without prejudice or subject to contract. It's helpful to mark the document in that way, but that in itself doesn't satisfy the rules. So there must be a pre-existing dispute for the offer to be genuinely without prejudice. So it's not sufficient just to include the wording, although that is helpful as a flag to both parties. So key questions to be to cover when you are making an offer to an employee with a view to entering into a settlement agreement. So the termination date we can see there on the slides. When will the employee be leaving the company? Will they be required to work their notice period? Will they be on a period of garden leave between now and the termination date? It's important that the agreement clearly states when the employee's employment will come to an end. Obviously, most settlement agreements are with a view to exiting the employee, but it is still possible to have a settlement agreement when somebody is remaining in employment. It doesn't have to have a termination date in, but in most cases it will be to bring the employment relationship to an end. Employers should be careful about entering into a settlement agreement too far in advance before the employee's termination date to avoid the risk of HMRC challenging the tax-free status of the compensation payment by saying, for example, that it's a payment for services rendered in between signing the agreement and the termination date. And you'll also have come across reaffirmation certificates, which we will come on to later. But essentially, if there's a gap between signing and the end date, usually we would use a reaffirmation certificate to cover any claims that may arise during that period of time. The compensation payment. So the amount of the payment obviously should be stated in the agreement, and it's helpful sometimes to consider whether the payment will be made is one lump sum or whether it will be offered in stage termination payments. If it is made in instalments, that can allow the company to save money if the employee does find a new employment during that period of time. The employee might also receive payments such as holiday benefits, etc. Again, they should all be set out clearly in the agreement. If the employee owes any money to the company, or if the company has the right to deduct payments for loans, overpayments, etc. from the employee's salary, this again should be clearly set out in the agreement. If not, then the employer might lose the ability to recover that money at a later date. And then the key question, how much should the company offer in any negotiations? As everybody will be aware, obviously that is a commercial decision, but it does depend on things like the employee's rights under the contract, so their notice pay and benefits, the amount of time that it would take them to get a new job, so that might be linked to any specialist areas or senior employees, and the strength of any potential claims that they might have. In practice, a company would usually expect to pay a sum that falls somewhere between the minimum contractual notice entitlement and the maximum that they could expect to receive if they were successful in any tribunal claims, but that would take into account their duty to mitigate their losses if they were to bring an employment tribunal claim. The more of the process that the company has followed, the stronger the arguments for the company and the greater the litigation risk for the employee. But obviously, sometimes these agreements are entered into at an early stage with a view to avoiding going through a lengthy process. Sometimes it's helpful for employers to look at if they have a particular formula for determining offers. So, for example, in a redundancy situation, you might offer enhanced redundancy based on, a particular formula that has been used or that is set out in a policy. The more often, obviously, that you use that, the greater the chances of it becoming contractual through custom and practice. So the employer needs to be seen to be making a fresh decision each time. And it's important that the settlement agreement clearly sets out the tax position with regard to the payments and the benefits that will be given to the employee. And then, so tax planning. So this links again to what payments are offered under the terms of the settlement agreement. So all pile-ons, payment in lieu of notice, are fully taxable, irrespective of whether there is a pile-on clause in the employment contract. Only the employee's basic pay for the unworked notice period will be subject to tax, so not other benefits and bonuses. And employers should ensure that the post-employment notice pay, the PEMP calculation, has been carried out to ensure that the correct amount is taxed as earnings. Sometimes we are asked whether it's possible to waive the notice and just add it as a tax-free payment under the compensation payment to give an additional benefit to the employee, but that isn't possible. The amount of money that is covered by the PEMP and should be the notice pay must always be taxed. So it's not possible to waive that and add it to the tax-free payment. The first £30,000 of any termination payment should be free from a charge to income tax, provided that the payment comes within the relevant termination provisions. And any sums over and above the 30,000 will be taxed in the normal way. So the companies often try and make sure that they make good use of that tax-free exemption if possible. Employers' NICs, NICs will be payable on termination payments above the £30,000. And we've made a note there, if the company's opening offer doesn't include any tax breaks, it can be, in some circumstances, additional scope to concede tax breaks as part of the negotiations. But I would say that that is probably going to be one of the first things that any lawyer acting for an employee will pick up on as part of the negotiation. So generally, I would say if you're willing to make the offer on that basis and you're satisfied that it would come within the tax-free exemption, then to make it on the first instance. And that means that the lawyer who's advising the employee has an opportunity to say to the employee, look, they've done what they can for you within the parameters of the legislation, and it gives a better chance of entering into the agreement overall. I'll hand back over to Lizzie now to cover some of the other key areas.
Thanks, Hannah. Okay, so other key questions and issues to be considering when you're drafting a settlement agreement include post-employment benefits. So are you going to agree to provide the employee with any employment benefits post-termination of employment, such as the use of a company car, for example, or possibly private health insurance? Are you going to agree to continue providing that to the employee? If you are, then you need to be setting that out clearly within the settlement agreement to avoid any dispute about that later on. It is worth considering whether or not you can agree to continue insurance benefits, as this can come at as a benefit to the employee, but at minimum cost to the company. So it is worth bearing that in mind. If you are prepared to continue providing insurance benefits to an employee, then it is always first worth checking with the relevant insurer that you're okay to do that, as sometimes it's not possible to continue providing insurance benefits post termination of employment. For example, rarely is it possible to continue providing life insurance cover to an employee. You could also consider stating that you will that any insurance benefits will cease for the employee on them obtaining alternative employment as kind of a halfway house. You could also consider providing the employee with payment of a bonus or commission as part of their settlement terms. And again, it's worth considering whether you can use that as a bargaining tool during negotiations. If you are going to provide payment of a bonus or commission, then again, like I said before, you need to be setting that out clearly within the agreement, as well as any terms relating to the payment of that amount. This sometimes, if we talk about bonuses for a minute, can be an area of contention, as employees understandably want to receive all of their payments on termination of their employment and upfront, whereas a company might be inclined to pay any bonus at the end of their bonus year, like at the same time that they will pay bonuses to any other employees that were entitled. Another thing to consider is pension rights. Is the company going to agree to make a payment into the employee's pension scheme as part of the settlement package? If so, then again, you should be documenting that in the settlement agreement. And you obviously need to take into account any rules relating to the employee's pension scheme, and double check that you can make the payment that you're wanting to make. It's also worth considering the tax implications of making that payment, and usually you'll be wanting the employee to be liable for any tax that becomes due on that payment later on. Another thing to consider is restrictive covenants. Does the employee's contract of employment include any restrictive covenants? And do you want the employee to continue to be bound by those restrictions post termination of their employment? If you do, then you'll want to state that in the settlement agreement and remind the employee of the restrictions that they are bound by. It's also worth considering whether or not you actually want the employee to enter into any new restrictive covenants as part of the settlement agreement, either because they don't have any restrictions currently included in their employment contract, or if they do have any existing restrictions, they might not be valid anymore, and so you might want to introduce new restrictions as a result. If so, then any new restrictions should be set out clearly within the settlement agreement, so the employee knows what restrictions they're being asked to sign up to. And it is usually advisable to attribute some money to the employee agreeing to sign up to new restrictive covenants, as you would do if you were including restrictive covenants in an employment contract. By assigning some money to the employee's agreement to take on new restrictions, by doing that, you avoid the risk of HMRC attributing all or part of the compensation payment to the covenants later on if it were to look at the settlement agreement, which would obviously jeopardize the tax-free status of the compensation payment if it was made, if the payment that was made was under £30,000. It can be worth considering whether or not you want to waive any restrictions and use that as a bargaining chip during negotiations with the employee. Something else to think about is legal fees. So are you going to make a contribution towards the employee's legal fees? And if so, how much are you going to contribute? It is standard practice for an employer to make a contribution towards an employee's legal fees and for taking advice on the terms of their settlement agreement, although it is worth stating that you aren't legally obligated to do so. The standard contribution is at the moment between £300 and £500 plus VAT, but it does really vary depending on the particular employee's circumstances, that possibly their position in the company, the extent of the legal advice that they need to take, etc. Now, if the employee's legal costs are going to be significant and they're actually receiving a payment in excess of the £30,000 tax-free sum, then there actually can be a tax advantage for the employee putting some of their compensation monies towards the payment of legal fees, as there is a tax concession which covers legal fees, but not any other professional fees, it is worth saying. A reference. So are you going to agree to provide the employee with a reference as part of the settlement package? If you are, then you need to ensure that any reference that is provided is true, accurate, and fair. It is good practice to agree the terms of any future reference that is being given, as well as the circumstances in which the reference will be provided, and attach the terms of that reference to the settlement agreement as appendix, as that will avoid any dispute about the terms of the reference in the future and a dispute about what was agreed. You do need to think about what you are able to say as part of an employee's reference, and whether or not there are any restraints on what can be included within the reference, possibly because of industry requirements. For example, if the employer works in a regulated industry and the employee was performing a regulated role within the company, and they're going to be moving to another employer and again performing a regulated role, then there are certain restrictions on what can be included in a reference in that context. Okay, so talked about references. Something else to consider is confidentiality clauses. Now, usually it will be prudent to include a clause within an employee settlement agreement which confirms that they're agreeing to keep the terms of their settlement agreement and the circumstances leading up to the termination of their employment confidential as part of the settlement. Now, you as the employer can make similar representations, although if you are going to do that, then you just need to be careful about what you're agreeing to do, as clearly it's much more difficult for you to control what your other employees say, whereas obviously the employee themselves has complete control over what they say about the settlement agreement, or don't say, I should say. Hannah's going to talk about confidentiality clauses in a bit more detail in a moment, as they are something that's come under close scrutiny in recent years. But if we move on then to talk about bad mouthing clauses, which again are often found within a settlement agreement. Now, these are designed to prevent the employee from making any derogatory comments about the employer and its other employees post termination of their employment. Now, strictly speaking, they can be quite difficult to enforce in practice, these types of clauses, but they are still useful to include, even if they just act as a deterrent and deter the employee from making any derogatory comments in the future. Again, you probably should expect to be asked to provide a reciprocal obligation. And if you are thinking of doing that, then just be careful about how you are drafting your bad mouthing obligations, for the same reasons that I talked about a moment ago in terms of the confidentiality clause. It is also worth noting that the Equality and Human Rights Commission has published guidance on the use of settlement agreements in discrimination cases, and that guidance does state that bad mouthing obligations should be mutual. So just bear that in mind if you're thinking of pushing back on a request to include a reciprocal bad mouthing clause within a settlement agreement. Okay, so return of property. A settlement agreement will normally require an employee to return any company property that's currently within their possession, either on or before the termination of their employment. That might be, for example, a company laptop, company car, any other hard copy confidential information. If you were going to allow the employee to retain any company property post termination of their employment, then you will need to make sure that you set that out clearly within their settlement agreement. And it can sometimes be valuable to allow an employee to keep, say, a mobile phone or a company car as part of a settlement agreement, because that might come at minimal cost to the company as opposed to other things. If you are allowing the employee to retain company property, particularly say a company laptop or mobile phone, then it's important to ensure that all the confidential information that might be held on that device is wiped before the termination of the employee's employment. And you also should be including a provision within the settlement agreement that confirms that this has been done. Full and final settlement clause. This is again a common feature in settlement agreements, and it does go without saying, but a settlement agreement should set out a full list of all the claims that are being settled under the agreement. As previously mentioned, it isn't good enough to just include a catch-all phrase such as the employee in full and final settlement of all claims is agreeing to sign the settlement agreement and receive a payment. You need to clearly identify the particular proceedings that are being settled under the agreement by the employee, which you need to do in order for the agreement to be valid and legally binding anyway. It is usual to expressly exclude from any waiver of claims any potential claim that an employee might have for accrued pension rights or for personal injury arising from matters that aren't known to the employee at the time that they sign their settlement agreement. So they're the usual carve-outs that you would be including. And ultimately, the aim of a settlement agreement is to get the employee to waive all and any claims that they might have against the company to the fullest extent that's possible under the law. And so it is worth spending a time making sure that that full and final settlement clause is properly drafted and does everything that you need it to. Final thing on the slide there to think about: do you need a reaffirmation certificate? Hannah mentioned these a little while ago. So you might want an employee to sign a reaffirmation certificate where there's going to be a material gap between them signing their settlement agreement and the termination date of their employment. What I mean by a material gap is probably a gap of 6 weeks or more, but it can depend on the circumstances of the case. And by signing a settlement reaffirmation certificate, what an employee is basically doing is affirming the terms of their settlement agreement. And also they'll be waiving their right to bring any claims arising from matters that have occurred within the intervening period, so between the date that they signed their settlement agreement and the termination date. So it is really worth asking an employee to sign a reaffirmation certificate where the circumstances warrant you to ask that. Okay, so Directors, when you're dealing with an employee who's a director and negotiating settlement terms with them, then there are some additional things that you need to consider. So the removal of an employee as a director will need to be dealt with specifically as part of the terms of their settlement, as directorship and employment are separate roles. So dismissing the director isn't going to remove them automatically from their position on the board unless you say that it will under their settlement agreement. So you should always have a clause that deals with the resignation from a directorship. You will need to check any relevant articles of association as well to check what form the resignation has to take, which should be set out if there is a specific form required. And you'll also have to consider whether shareholder approval is required for paying the director anything over the odds in their settlement agreement. And it is often difficult to pay anything over the odds to a director without shareholder approval. It is worth flagging that. Also consider the timing and content of any announcement announcing the departure of the director and what potential impact that could have on the business, for example, business results. You'll also have to deal with the transfer of any shares from the director under the terms of their settlement agreement. And it's also worth remembering that any sums paid to a director under their settlement agreement might become publicly available later if it's set out in company accounts, for example. Now, departing directors are going to probably ask for certain assurances under their settlement agreement, and a common one is an assurance that they will continue to be bound by directors and officers indemnity insurance, which will cover them against any claims that might arise in the future from decisions that they made during their tenure as a director. And that is something that usually you can negotiate as part of settlement terms, provided that you are making sure you're not overcommitting in that respect. Okay, and I'll pass back to Hannah now.
Great, thank you. So, as Lizzie mentioned earlier, confidentiality and non-disclosure provisions have come under close scrutiny in recent years, really ever since Zelda Perkins went public about her experience in agreeing her NDA following her employment with Harvey Weinstein. There's been a close focus on this, although her settlement agreement was definitely not typical. She was even prevented from having a copy of the signed agreement. But concerns were raised that other employers were using NDAs to prevent employees from reporting unacceptable conduct. So, for example, allegations of sexual harassment. In response to this level of scrutiny, the SRA, the Solicitors Regulation Authority, issued a warning notice to the legal profession on NDAs in 2018, and this was then updated in 2024. The notice doesn't prohibit the use of NDAs, and it does cover any form of agreement or contract or a clause within a wider agreement or contract. So it will cover clauses in settlement agreements. And the notice sets out a reminder of some of the key issues and risks that advisors should be aware of when dealing with NDAs. And this is why you often see wording, I'm sure you've come across it in settlement agreements, which makes it clear that nothing in the agreement will prevent somebody from, for example, making a protected disclosure under the whistleblowing legislation. In terms of recent developments, Section 17 of the Victims and Prisoners Act came into force on the 1st of October this year, 2025, and that provides that provision in agreement, which would cover a settlement agreement or a COT3, is void if it attempts to preclude a disclosure of information by a victim of crime or a person who reasonably believes that they are a victim of crime. It won't be relevant in the vast majority of cases, but it's important that it isn't overlooked, particularly where there are allegations of harassment, for example. And therefore, we are often updating settlement agreements to include wording that carves that out of any confidentiality clause. For any employees who work in the financial services sector, such as the FCA, the FCA and the PRA rules require that firms have to include relevant wording in settlement agreements, which makes it clear that workers have the right to blow the whistle, essentially. And finally, just to flag that the government is looking to legislate further in relation to NDAs in the context of harassment and discrimination claims. We don't have many details at this stage, but in brief, the government will be seeking to further restrict the use of NDAs by employers in the context of harassment and discrimination claims. And again, that will likely apply to settlement agreements. The government's impact assessment states that the government's aim is not to reduce or ban the use of NDAs in appropriate circumstances, but to prevent employers from misusing them to silence workers about misconduct, with the ultimate intention of changing business culture to reduce harassment and discrimination. So we'll obviously keep you updated on that as things develop. I'll move on now to run through some common pushbacks that we often see when advising on settlement agreements for employers. So these are some of the key areas where we see employees or their advisors coming back to renegotiate some of these terms. Usually once the financials are sorted, the hope is that the rest of the agreement and the relevant wording will follow, but there are some key issues that tend to crop up again and again. So the first one is the reason for dismissal. Often employees might want the reason to cover redundancy, for example, even where there may not have been a redundancy situation, but the company shouldn't state that an employee has been made redundant if that isn't the case. A redundancy dismissal can trigger other contractual entitlements. So, for example, change of control provisions, enhanced redundancy payments, good leaver provisions in any share entitlements. And the reason stated can also impact the individual's ability to claim state benefits or mortgage protection payments. So if an employee relies on redundancy to make a claim on an income protection policy where there hasn't been a genuine redundancy situation, it could constitute fraud on the insurance company in which the employer may be implicated. So all that is to say that ensure the reason set out in the settlement agreement is consistent with what's stated in any reference and consistent with the factual circumstances. Even where an employee or their advisor is asking for the reason to be stated as some other reason. It's also not mandatory to actually refer to the reason for termination in the agreement itself. So if it is a mutual termination, a mutual agreement, it is possible to simply refer to that within the agreement itself. Tax indemnities. So these are usually covered in every settlement agreement, and it is standard practice for employers to require an employee to indemnify them if they incur any liability for further tax and employee NICs, because HMR claims that any payments should have been subject to tax. So this is obviously relevant where the employer is relying on the tax exemption that I mentioned earlier for sums payable under the £30,000. HMRC will generally pursue the employer and not the employee directly, because it's a bigger target and it's the employer's responsibility to account for tax on earnings of employment. So therefore, by including the tax indemnity, the employer has the right to reclaim any sums from the employee, assuming it's prepared to take action to enforce the clause and that the employee is actually worth suing, as in, do they have funds to account for the money? An employer can't be indemnified for employer NICs, but such a clause is, however, only as good as the employee giving it. Any attempt to remove the tax indemnity should generally be resisted, especially if there is a tax-free payment being made. And usually, if it is resisted, in my experience, usually it is accepted in order for the employee to receive the tax-free benefit of the compensation payment. Alternative employment. So a settlement agreement usually requires an employee to confirm they've not received any suitable job offers since losing employment. So including that clause, the agreement could include that the termination payment can be withheld if they find that the employee has a new role. Obviously, again, that will depend on the circumstances. A redundancy situation, for example, it may not be appropriate to include that type of clause in the agreement in any event. So how really whether that is pushed back on depends on how keen the employer is to get the deal done, how much money it's offering, and also the particular circumstances of the exit for the employee. Non-disparagement, we've mentioned earlier, Lizzie's mentioned that, so I won't go through that again. And then outplacement counselling and legal fees. Sometimes employers agree to pay for the employee to attend outplacement counselling. It can be quite a cheap way of sweetening the offer, and it's often a real benefit to an employee, so it is something worth considering. No liability to tax arises where the only or main purpose of the services is to enable the person to adjust to the termination or to find other employment. And the services consist of giving advice and guidance, improving skills, etc. And the individual's been employed by the employer for 2 years. And provision of the services is available to all employees. So there is a tax advantage there if those criteria are met. We've already discussed the legal fees in terms of a standard contribution, which we usually see as around £300 to £500. And Lizzie's already mentioned that sometimes there can be a tax advantage in upping that payment rather than the compensation payment where it's hitting the £30,000 cap. Again, how much of a contribution the company is willing to make is often a matter for negotiation. So we'd usually start around that 350 to 500. But again, it can form part of the overall negotiation in terms of increasing that figure. Okay, so I am 1 minute away from time, so that will bring the webinar to a close today. Thank you all again for joining us. If you do have any questions, we would be delighted to hear from you. Because I've run out of time, we will be circulating the webinar slides and recording the link after the webinar, so please do keep an eye out for that. And if you could send us any questions in, if we do have any, we can cover them in a blog post after the session as well. So thank you all very much.